Hello, my presentation title is called Are Easements in Need of Reform? I will be explaining the different ways easements are created and how they end. Firstly, we need to define what an easement is. In Halsbury's Laws Book, it was defined an easement is a right annexed to land to utilise other land of different ownership to do something on that land, or to prevent the owner of the other land from utilising his land in one of a limited number of ways. There is also another category of easements which are called profit apprendre. In Halsbury Law's Book, it was defined as the right to take something off another person's land. Also, a right to enter another's land to take some profit off the soil, or a portion of the soil itself for the use of the owner of the right. There are four examples of this. Profit of pasture is the right to graze animals on land. Profit of pescari is the right to take fish from water. Profit of stovers is the right to take wood, and profit of turbary is the right to cut turf or peat. In regards to an easement being found, it must meet the requirements set out in the case of R.E. Ellenborough Park, 1955. In the case, it sets out that there 1. Must be a dominant and servient tenement. 2. The dominant and servient tenement must be owned by different people. 3. The right must accommodate the dominant tenement. And 4. The right must be capable of forming the subject matter of a grant. The final criteria also has sub-criteria that needs to be satisfied. A. There must be a capable grantor and grantee. B. The right must be sufficiently definite. C. The right must be similar to existing easements. And D. The right must not totally exclude the servient tenement owner. Now I will explain the ways easements are created. They can either be created through a grant or reservation. A grant is where land is sold by seller to buyer and the buyer is granted an easement over the seller's retained land. For example, if a seller sells part of his large garden, then in the transfer deed it grants a right of way for the new owner, who is the buyer, to use a path over the seller's retained land to access the land purchased. Reservations. A reservation is where land is sold by seller to buyer and the transfer deed gives the seller an easement over the buyer's land. Essentially, it is an easement reserved to the seller over the land that they have sold. There are two types of easements that can be created. The first type is an express easement. These are either granted or reserved expressly in words. This may be in a transfer deed or deed of grant, nonetheless in a written agreement. Express easements must also meet formalities, whether they be legal or equitable. The second type is an implied easement. This will be implied by court into the deed of grant, transfer deed, or contract. This is further split into different methods which can be seen on the screen. I'll now go on to discuss these methods in detail. The first method is called implied through necessity. The courts will only imply the easement if the use of the dominant tenement land is impossible to use without the easement. This was highlighted in the case of Union Lightwich Company and London Graving Dock Company, 1902. As the judge stated, in my opinion, an easement of necessity means an easement without which the property retained cannot be used at all. This was then used in cases in more recent times, as shown in the case of Mangan and Drama, 1991. The court ruled that a right-of-way could not be found in this case, as they had alternative access available via water. This essentially meant it was not impossible, and that is part of the criteria to be implied through necessity. The second method is called implied common intention. This is implied by the court if the person could show that the parties intended to grant or reserve the easement. The court will look at the purpose for which the parties intended for the land to be used. This can be illustrated by the case of Wong and Beaumont Property Trust, 1965. Mr. Wong had bought the property downstairs with Beaumont Property Trust still owning the property above. It was leased to be a restaurant. However, Mr. Wong needed to provide a ventilation duct under health and safety regulations which would need to go through the upstairs premises. But Beaumont Property Trust refused. The courts implied an easement of necessity into the deed of sale as it was necessary for the premises to run as a restaurant as it was part of the lease. The courts tend to favour implied common intention in the case of grants rather than reservations. This was shown in the case of R.E. Webb's lease, 1951. Lord Jenkins said, if the seller of land intended to reserve any such rights over the land, it was his duty to reserve them expressly in the conveyance. The third method is an implied grant under the rule in Wealden and Burroughs. In this case, there were conditions set out to determine this type of easement. Whenever parts of the land that have no diversity of occupation and is sold, these rules are required. Firstly, it must be continuous and apparent. To define continuous, it means that the right must be used on a regular basis, and for it to be apparent, it means it has to be visible. The second condition is that it must be necessary to the reasonable enjoyment of the land sold. And lastly, it must be in use, both previously and at the time of the sale, for the benefit of the part of the land sold. The final method is implied grant under Section 62 of the LPA 1925. This allows for the benefits listed under Section 62 to pass through in a conveyance of land. This is best shown in the case of Wright and McAdam, 1949. Mrs. Wright was a weekly tenant in her flat in Mr. McAdam's house. She was given permission to store coal in his shed. She was then given a new tenancy of the flat. It was held. This was recognised as an easement and was implied into the document granting the new tenancy. Easements by prescription. The basis of gaining an easement by prescription is that you have used the right for a long period of time. There are three conditions that need to be met with this. Firstly, it must be nec v, which means without force. Secondly, it must be nec clam, which means without secrecy. Lastly, it must be nec precario, which means without permission. The three methods of creating an easement by prescription are common law prescription, the fiction of the Lost Modern Grant, and the Prescription Act 1832. I'll go on to discuss these methods in more detail. The first method to consider is common law prescription. Historically, interest had to be shown since time immemorial and ruled since before the 3rd of September 1189. This has since changed to within living memory, and evidence of use for at least 20 years is sufficient. However, this can be rebutted if evidence is shown that the right claimed begun after 1189. This was shown in the case of Duke of Norfolk and Arbuthnot 1880. The case held no right of way was established as the church in question was built in 1380. The second method is the fiction of the Lost Modern Grant. This deals with the rebuttal of presumption under the first method. This was shown in Dalton and Angus and Co. 1881. Where there has been at least 20 years of use of an easement, the law would adopt a legal fiction that a grant was made by deed. However, this method is also rebuttable if the grantor was mentally incapable, or if it can be shown that the dominant and servient tenement are in common ownership. The final method is through the Prescription Act 1832. This requires 20 years of continuous use before the issuing of court proceedings. Section 2 of the Act states that you must have at least 20 years of use. Section 2 also stipulates that if the use by the servient tenement is interrupted for over a year, then the claim will be defeated. Section 4 states that this must be continuous use up to the time you claim your right. The Prescription Act is divided between a short period and a long period. The short period requires easements to be of 20 years use and a profit of prongers to be 30 years. When you consider the long period, this increases in years for both types. Easements are extended to 40 years and profit of prongeur is extended to 30 years. However, with a show of 40 years uninterrupted use, there is an absolute right to an easement. For this reason, this is the strongest method to gaining an easement through prescription. But this claim can also be defeated in a number of ways. It can be defeated if written permission was given at the start of the 40-year period, and it is also defeated by oral or written permission during the 40-year period. So now I will be looking at how easements come to an end. These are listed on the screen. The one I will be focusing on is implied release. Implied release has to be shown through conduct. This was shown in the case of Moore and Rawson 1824. The claimant's predecessor rebuilt land and put a wall up where there was previously a window. Therefore, the claimant could not claim an easement. This is because the predecessor had shown an intention to never make use of it again. Another case followed, which was Ben and Harding 1992. In this case, nobody had used a right-of-way for 175 years as there was alternative access being used. For this reason, the court felt that it had not been abandoned. This is because they deemed there was no intention to. This brings us on to abandonment. Abandonment depends on the intention. This means a dominant tenant must show a clear intention that he or any of successors in title will have any future use of an easement. Abandonment needs to be defined, and what constitutes abandonment. For example, non-use does not show abandonment. There have been cases regarding this and has provided confusion in the case of CDC 2020 PLC and Ferreira 2005. There were garages which were demolished and replaced by a two-storey car park. After 30 years had passed, the garages were rebuilt. The defendant argued that it had been abandoned. However, the courts would not infer abandonment lightly and the claimants were allowed to use it again. Reforms. The Law Commission have seen easements as an area of law that requires reforms. They are looking to come up with a scheme that can be compatible with the Land Registration Act of 2002. I've listed some of the reasons why they are looking for reforms. Prescriptions are seen to be outdated and difficult. Rules relating to prescription and abandonment need simplifying, and implied easements are confusing. Due to these issues, the Law Commission have proposed reforms. These can be shown on the screen now. I will now go on to examine the reforms that can be made for easements. Abandonment reform. The Law Commission have recommended to presume an intention to abandon an easement or profit or plunder following a continuous period of 20 years non-use. The reasons for this are: in the case of Ben and Harding 1992, it showed how the rule of non-use is not rational. This is because you would assume after 175 years that it will show that the easement is abandoned and that the party has no use for it. Also, the courts seem reluctant to deem an easement to be abandoned, as shown in the case of CDC 2020 PLC and Ferreira 2005. This would change the law dramatically and have non-use as an intention to abandon. Prescription reform. Forming easements through prescription has been deemed outdated and difficult. The Law Commission have recommended that there be an introduction of a single statutory scheme to simplify the law. Firstly, one problem with common law prescription is the requirement of the right having been used since the 3rd of September 1189. Having this time frame from hundreds of years ago seems to be arbitrary and obscure. Getting rid of this time frame seems logical. For this reason, the Law Commission have recommended to replace prescription with a single statutory scheme. This would simplify the law, as instead of 3 different methods, it would produce one coherent scheme to be followed. These are the reforms I have provided. That is the end of my presentation.